everybody, hold up. The sun is hitting me right in the face, and there's nothing that I could do about it right now. Welcome, everybody. Welcome, welcome. Thank you, Podcast Queen. Thank you for telling me to hit that like button. Let me let the people know that I'm live because I didn't tell people that I was live. I just literally just went live because I just saw this and I said, "Whoa!" And I was recording for my next video that I'm about to drop, and I have so much editing to do. We live now. Welcome, everybody. Um, so shout out to SF Investigates because I found this information through SF Investigates, and there's so much stuff happening. Shout out to the people that are messaging me about the Epstein stuff. We'll definitely talk about that. I just been, like I said, I've been in recording land, and I'm also looking into the Diddy stuff, and it's a lot of different things that I'm like. My mind's not here. I'm here, but I'm not here. We live, everyone. Hey, everybody. Hey, BJ. How are you? Shout out to everybody. In my mind, I'm just like I'm busy. My mind is busy. I got too much stuff. And the sun, I might have to move somewhere else. Yo, this is gonna bother me. The sun is hitting me right here. I can feel it and I see it. Hey everybody, thank you for hitting that like button. Shout out to BJ in the chat. Thank you. She says, I'm here. Yay. Welcome everybody. I'm letting the people get in here. Give people some time while I set up. Give me 1 second. Is this hold up? I don't think this is going to be a very long live, but okay, where did it I'm like seeing things. Here we go. So shout out to SF Investigates. You guys know he's a channel friend. Shout out to SF Investigates. So he posted some very interesting documents. Now tomorrow we have the Emmanuel Haro here. Well, we have the hearing for the parents, right? And I know a lot of us are kind of like anticipating what's going to happen, what's going to happen. So we'll definitely be live around that time. And hopefully we'll get some live updates. We will see. You said I just saw YouTube that Emmanuel Haro remains have been found. Don't know if it's true. Just what I heard. Really? I don't know, Priscilla's. And the thing is we don't know if you heard it from a YouTube channel. I don't know, man. Just ask them where they got their information. But yes, thank you. Your blanket is cute. Did you decorate it? My blanket. The frame. The bedazzles, yeah, we just bedazzled it. Hey Belen, hey everybody. Okay. Not again. I haven't heard anything, so I don't want to. I want us to be careful, but every YouTube channels, there's AI YouTube channels that are giving misinformation, y'all. Be aware that not everything that you hear is accurate. That is put out there, even if it's from your favorite YouTuber, make sure you guys are doing your own discernment and research, because like I said, everybody does something different. I know it's proof or it didn't happen. Well, I know BJ's in here. Shout out to BJ. Sources are always important. Absolutely. It would be all over if he was found. I hope that it's true, but I don't think it is, honestly. I don't know, man. Be very cautious. Anyways, let's get it together. So SF Investigates posted this about 21 hours ago. I missed it, man. I'm telling you, I'm in a different land right now. This excerpt is from the 2023 sentencing transcript of Jake Haro, related to a 2018 beating of his child that left her permanently brain damaged and disabled. Okay. Hold up, y'all. You ready for this? Yeah. What is it? What is it? What is it? She got a thing of slime. Sorry about that. Let's keep going. Related to the 2018 beating of his child that left her permanently brain damaged and disabled. He was initially sentenced to 6 years in prison, but the sentence was reduced to 4 years of probation. The district attorney objected on the record. Okay, so there's an objection on the record about the sentencing. And while the judge acknowledged the objection, he stated that he had hung a very high hammer over the defendant's head. Ooh. So again, these are receipts from SF Investigates directly. And let's look at those, okay? Shout out to SF. It says, the court, all right, then on that basis, probation is denied. Based on the defendant's stipulation and the plea agreement with the court, the defendant is sentenced to the aggravated term of 6 years in state prison. I want you to let that sink in for a minute. I just sentenced you to 6 years in state prison. I will then suspend execution of the sentence and place it. Give me 1 second. And place it. Hold up. I want you to let that sink in for a minute. And I just sentenced you to 6 years in state prison. I will then suspend execution of that sentence and place you on supervised probation for a period of 4 years. But if you violate your probation, you've already been sentenced to 6 years in prison. There will be no argument about, well, that's too much. Maybe we should give him less. No, you've already been sentenced to 6 years. Do you understand that? Defendant Haro, I do, Your Honor. You guys, I'm gonna have to reread that so I let that sink in a little bit so I understand, because I know that some of the journalists have, I mean, this is straight from the transcripts, you guys, straight from the transcripts, which I have ordered and I have not received yet. He did violate. He should have been locked away. That's right. Straight from the transcripts. Let me go back a little bit because I know that I was all over the place. That last paragraph, I want you to let that sink in for a minute. I just sentenced you to 6 years in state prison. I will then suspend execution of that sentence and place you on supervised probation for a period of 4 years. But if you violate your probation, you've already been sentenced to 6 years in prison. So basically, if he violates, which he did, he says that if he violates this, you've already been sentenced to 6 years in prison. Then he further goes, there will be no argument about, well, that's too much. Okay, so he says there's not going to be an argument like that's too much. Maybe we should give him less. No, you've already been sentenced to 6 years. Do you understand that? I do, Your Honor. Okay, so then there's that. There's one piece right there, and then SF Investigates gives us another piece. He says, during the sentencing of Jake Haro for the 2018 beating that left his daughter brain damaged and permanently disabled, the judge issued a protective order prohibiting Jake from contacting her in any way. However, the judge then asked whether this aligned with any existing CPS or court orders. When asked if he had any visitation rights with the daughter he had nearly beaten to death, Jake stated that Vanessa had 2 days of visitation per month and he had 1 day per month, presumably allowed by CPS. Jake also stated that during the 2023 hearing, that he had not seen his kids, plural, in 3 years. The judge ultimately issued the protective order, but clarified that peaceful visitation would still be permanent if it was consistent with any existing court orders. Oh, this irks my soul. Like, you guys don't even know. Hold up. This makes me so mad. You guys don't even know. Like, this makes me so mad. This is what SF says, okay? During the sentencing of Jake Haro for 2018 beating that left his daughter brain dead, we know this, the judge issued a protective order prohibiting Jake from contacting her in any way, okay? However, the judge then asked whether this aligned with any existing CPS or family court orders. When asked if he had any visitation rights with the daughter he had nearly beaten to death, Jake stated that Vanessa had 2 days of visitation per month and he had 1 day per month. CPS was allowing, whether supervised, I don't give a crap if it's supervised. CPS was allowing Jake Haro, the man who put his hands on this 10-week-old baby, visitation. Once a month. Twice for Vanessa. Once a month. When asked if he had any visitation rights, this is what he said. Jake stated that Vanessa had 2 days of visitation per month and that he had 1 day per month, presumably allowed by CPS. Jake also stated during the 2023 hearing that he had not seen his kids, plural, in 3 years. The judge ultimately issued the protective order, but clarified that peaceful visitation would be still permitted if it was consistent with any existing orders. Oh, let me read this because I'm about to I'm literally itching out of anger. I'm itching, and out of frustration. To say that CPS failed these kids is like a complete, like it's an understatement. Like, what? Yeah, and he was allowed to visit, y'all. I don't either. This is crazy. Let's keep going, okay? Violating your probation. Okay, so he showed us one sheet, and then this is the next one. Is he the parent of the child? Mr. Taloa said yes. I don't know who is Mr. Taloa. Maybe it's another attorney, but it says, the court, is there any juvenile court family CPS? What is the status of that? I mean, typically, we will permit contact pursuant to and only pursuant to a subsequent court order regarding visitation. Why wasn't CPS communicating with this criminal case? This criminal case is what led CPS to be involved. This is weird. Mr. Sarmiento says, Your Honor, I have no objection to checking the box reflecting the incorporation of any future family court order. The court says, that's 14B. Mr. Sarmiento responds, that's fine, Your Honor. I believe, I don't have all the details, but there's another family court order. The court says, is there an order providing for custody already in existence? Mr. Sarmiento says, based on my brief discussion with him, yes. He does have visitation at least once a month. There's a typo here. Okay, so Sarmiento is the lawyer for Jake Haro in this case. The court further goes. The problem is I don't have a case number for that. Mr. Taloa says, I don't have access to that either. I think Mr. Taloa is the DA at the time. The court says, do you have any more court appearances coming up in that case? Defendant Haro says, I do not, Your Honor. The court says, what are the provisions in that case? Defendant Haro responds, Vanessa Avino was allowed 2 days a month. I was allowed 1. I haven't seen my kids in almost 3 years. Yes, I'm aware of this, but it's a little bit, well, listen, I didn't work CPS in California, but there are different set of circumstances when the reason why a child is in the state that the child is in is because it was due to that parent and what that parent did to that child. Visitation, before anything, there should always be a parent interactional, especially when it was the parent that did all this. Now, this child is nonverbal, my understanding, can't communicate, right? So I have a lot of questions about this visitation. Was there somebody else in the room? Why was it permitted? What interaction did they have? Once a month, and he's the one that put her there? Yeah, no. I don't know. Anyways, let me keep going. Another piece of court paper. The court says because we don't have those details, it would normally be in the form. I'm amending the language to say it's a no contact order, except you may have peaceful contact as an exception to the no contact order. Why didn't the court contact the CPS? You can order CPS. I mean, You can order them to be involved in this case too, or go testify. I mean, yo, like, this is dumb. This is the criminal case that led CPS to be involved unless they were involved before. This is so dumb. This is dumb. Sorry, I'm having a moment because I'm like, what? The court says because we don't have those details, it would normally would be in the form of I'm amending the language to say it's a no contact order, except you may have peaceful contact. What the hell is peaceful contact? What's peaceful contact? Supervised contact is not peaceful contact. What is it? It doesn't make sense. As an exception to the no contact order, only for court order visitation, as stated in any family, juvenile, or probate court order issued before or after the date this order is signed. Let me look this up. Is this a legal term? California peaceful contact. Okay, it says a peaceful contact protective order could allow the defendant to continue living with the victim or contact them by phone or other electronic devices as long as the contact doesn't involve violence, threats, stalking, or intimidation and remains peaceful. This child is nonverbal. Okay? Like, even if he was harming her, she wouldn't have been able to speak up, if you know what I mean. This makes no sense. He shouldn't even have had any kind of contact whatsoever. Like, that's just crazy work to me. Hold up. Y'all let me know what you guys think. My stomach hurts. Let's keep going with this document. Thank you, Bossy. Shout out to Bossy, who's been a member for 22 months. No contact order should be no contact at all. But peaceful contact to a child, to the victim, like, that he left this way, doesn't make sense. This is where things are not ever aligned, but in the judicial system and the CPS system. The reason why he got himself in this judicial system is because of the things that he did to this 10-week-old baby who could not self-protect, advocate, speak out, or anything. Okay, so then he makes this ruling, but in my mind, I'm like, why? The DA could have contacted CPS, the court could have contacted CPS, they could have contacted, the city assistant attorney or the attorneys that are working there for CPS that represent CPS. They could have done all that to bring them in and make them party to the case or give a recommendation or maybe a parent interactional or something. This doesn't make sense. Doesn't make sense at all. Anyways, let's keep going, man. He says, is that agreeable to both? So after he says no contact only for court order visitation, as stating in any, so he says right here, as stated in any family, juvenile, or probate court issued before or after the date this order is signed. You should just contact the court that made whatever decisions on the child's well-being. Is that agreeable to both sides? Mr. Sarmiento says, I would agree with that. Mr. Taloa says, yes, Your Honor. The court says, okay. That will be the order. Mr. Sarmiento says, okay, thank you, Your Honor. The court says, if you go outside the scope of your court permitted visitations, you're violating this order. And you know what that means. 6 years. So don't. I think that covers everything. Yo. So basically it was like, if you do this, you're getting 6 years. And that violates everything. Okay, let's keep going. 21 hours ago, this is shout out to SF Investigates again. The district attorney's office objected to the sentencing of Jake Haro, stated on the record that their offer included a prison term, prison being defined as more than 1 year, whereas jail is less than a year. The DA's office did not sign the sentencing agreement. Mr. Taloa appeared on behalf of the DA's office while Mr. Sarmiento was filling in for Jake Haro's regular attorney, Vincent Hughes. Okay, cool. So Mr. Sarmiento was a fill-in for Vincent Hughes. Okay, that's good to know. Mr. Taloa is the district attorney. At that time, was the district attorney. Mr. Taloa says, Your Honor, I would just ask for the record to reflect that the people are objecting to this. They're objecting to what the judge is saying. And this is based on the severity of the injuries. As we discussed to the victim, and our offer was, in fact, prison for this case. Mr. Taloa, if you objected to all of this, couldn't the DA's office have appealed whatever this visiting judge was ruling at that time? That is the question that I have. The court says, understood. Mr. Taloa says, thank you. The court says, I acknowledge that when I said it was a plea to the court and that people aren't joining in it, I appreciate that. Under the circumstances, I think this is appropriate. And we have hung a very high hammer over the defendant's head. If he violates, he'll end up going to prison for a long time than if I had taken the DA's deal. I'm giving you a chance. Don't mess it up. Good luck. This is what the judge says. Mr. Sarmiento says, thank you, Your Honor. Defendant Haro, thank you. The court says, thank you. And that was adjourned. Okay? The complete BS. High hammer. I'm telling you, it was a feather, not a hammer, girl. It was not. And it was a visiting judge. Thank you, Martha, for telling people to hit the like button. I really do appreciate it, guys. Please, my 2 videos on this topic have gotten flagged. I have to be careful when I talk about this. So please do me a favor, at least support by hitting the like button. Thank you. Appreciate it. Rebecca knew what he did to that child and still married him. She was there when the sentencing was happening. She was around. So she knew what the hell. Let's keep going, okay? So that was the judge. Whew, man, that just really makes me upset. Okay. So, and then the last posting, this was 2 hours ago. And I think, shout out to SF because he's like reviewing this. If you guys remember, about 2 weeks ago, SF came to my channel and he gave us an idea. SF called it 2 days before the arrest happened. He's like, they're going to come for them. And then bam, it happened. I think it was a day before the arrest happened. Yeah, so shout out to SF because, like I said, it's really cool to have somebody in the field give you some professional input on a lot of this stuff. He says, this was 2 hours ago. I'm really confused by Kim Degonia. She's the same person who claimed that Jay Caro confessed. So Kim Degonia was the attorney that was sitting down with Brian Enten. Do you guys remember she did that interview with Brian Enten? And they both were giving commentary about a confession and a Perkins deal or a Perkins confession. Okay. So SF says, I'm really confused by Kim Degonia. She's the same person who claimed that Jay Caro confessed. Now she's saying that the Riverside DA's office hasn't taken action to revoke Jake's probation for the firearm violation. That's the question that I have. Okay. Remember, while he's on probation, he picked up a weapons charge last year. Which I'm wondering, well, why wasn't he violated? Because then he wouldn't have been around with the baby, right? Like he wouldn't have been around with baby Emmanuel. He would have gone back because this hammer was so high, right? Right on top of his head. That's what that judge said. Okay, so it says, now she's saying that the Riverside DA's office hadn't taken action to revoke Jake's probation for the firearm violation. In reality, he was arrested and then released in July 2nd of 2024 on a $50,000 bond. On July 10th, 2024, a violation of probation was formally alleged and docketed. A hearing was held August 9th of 2024, during which his probation was revoked. An arraignment on the matter was scheduled for October 7th, and he has remained out on the original bond since. What? Okay, so why is that? That was the question that I had. Like, why is that? While the court has granted continuances that have allowed the case to drag on longer than it should, her claim that it's been a year, nothing has happened with the probation violation is simply not true. His probation has already been revoked. But why did the court grant continuances? Yes, the violation needed to be proven in court for the suspended sentence to be enforced, but the delays were due to judicial continuances, not inaction by the DA's office, although the DA's office should have sternly objected to the multiple continuances. They kept putting it off. Well, that is crazy. What are they doing? Why does it seem like a cover up? That's what it seems like. Like, it seems to me that if he picked up the weapons, what is it? The violation was, hold up, what was the date? He was arrested and then released July 2nd, 2024. He was already on probation. He posted bond for 50,000, okay? And then July 10th, a violation of probation was formally alleged. So it went from the 2nd to the 10th, and then there was a hearing in August, and then at that hearing probation was revoked. And then there was an arraignment on the matter on October 7th, and he has remained out of original bond since. So it was the court who had been granting continuances, a year of continuances since his violation, a year and a month or 2 months since his violation. It just kind of kept going and going and going. So I do wonder, well, what are we doing here? Tinkle Tits, thank you for the $9.99, my love. Algorithm boost. I really do appreciate it. Yeah, Bossy says probation was revoked and he should have gone directly to prison. But then he put that 50,000, right? So then they kept pushing back the hearings. If there were no continuances, God, I hate using that. If there were nothing, if it wasn't for this, if it wasn't for that, because it almost feels like, man, the failure was there, right? This is what I heard too. So what they did is for this right here, for this weapons thing, it was pushed to September 2nd this week. And then they were like, well, no, we're going to push this right here over to tomorrow's hearing too. Crazy. Like crazy, crazy, crazy. Yeah. You said, here's a question. He was still on probation this whole time. Do probation officers not check with their people? Go to the home? Yes, they do. They do. There needs to be a registered abuse in all 50 states, right, Connie? I would agree with you on that one, love. Thank you for being a member for 3 months. But the thing about CPS system, it's not a national system. It's only every state has something different. So if I'm working in one state, I can't check what Nevada is doing or California is doing, if that makes sense. It doesn't work that way. And even if it's like an SO, some of those crimes don't even get docketed. Like there's the reason why there's a lot of pushback on a system like that is for privacy reasons. That's why. I mean, I remember this discussion. I remember I went to DC one time about this situation right here, and this was years ago, guys. This was years ago. Like this right here, needing a system, it's not new. Go watch Gabriel Hernandez, the trial of Gabriel Hernandez. Go watch that, and you'll understand that this has been talked about so many. But the thing is, it's like people don't report, or they don't say anything, or they get complacent. That's what they do, you know. Hold up, and thank you, Connie. Shout out to you, Connie. Yeah, pretty much. Pretty much. Okay, hold up. Now, let's see what else he says. So this is the paperwork. Hearing on petition to violate, revoke, modify, to terminate probation pursuant to 1203.6.2b at 8:30 a.m. in Department B101. Judicial officer none. Court assistant none. Court reporter none. Okay, no appearances. All right. Hold up. Honorable Judge Francisco Navarro presiding. Court reporter was K. Yanis. People represented by Deputy District Attorney Alex I don't know how to say his last name. Defendant represented by Vincent Hughes. There's Vincent Hughes right there. So he was well aware of that 2024 weapons violation. He was the attorney for that. Defendant present. Probation order revoked. Violation of probation arraignment hearing on October 7, 2024. Defendant enters general time waiver. Are you going to get this? Yeah. Okay. Girl, what you, let me see. Let me get this out. Oh my God. Y'all, you are crazy. Okay, we're gonna have to get that out in a minute, okay? All right, girl. This girl. Sorry about that. I got distracted. Defendant enters general time waiver. Defendant ordered to return to any and all future hearing dates. Okay, bail bond continued. Legacy minute order. Hearing on petition to violate, revoke, modify, or terminate probation. Hearing set. Bond bail posted on. So this is when he posted the bail bond on July 2nd for violation of probation. Look it, and then on August 1st, proof of completed child abuse class filed. Oh, it's going. I'm reading it wrong, y'all. I do apologize. So it's like basically from the bottom up. I was reading it down, or from the top down, but it's bottom up. July 2nd, bail bond filed. Appearance date July 9th. Bail bond to be addressed by June 27, 2026, which is 2 years from the effective date. So he posted a $50,000 bond. He got that money from somewhere. Okay. Release on bond. And then the date appearance was August 9th. Why did he complete another child abuse class in 2024 on August 1st? Or unless this is something else, or it's proof of completion. So maybe he gave him a certificate that he completed this course, and it's proof of that. Okay. Hearing set on bail bond posted June 2nd, 2024, violation of probation. Okay. So it's just like giving us a minute order breakdown, but there's nothing, it's kind of hard to kind of read through that. I want to get the transcripts for this so badly. He actually posted bond on the day that he was arrested, the June date, but wasn't filled until July 2nd. It does make you wonder if maybe he had to stay there for a while. Yeah, how does he afford bail and bond with no job? Violation of probation. Somebody must have signed for him. Violation of probation is non-bondable offense, right? That's what I thought. Somebody must have signed for him. You know what I mean? Yeah, thank you, Regina. Classes for leaving a child vegetated in a vegetated state. Natasha, thank you so much for the support. Thank you for the super sticker. This is a joke, you guys. Shh. Man, oh man. Anyways, no more. I don't have any more, honey. Yeah, I don't have any more. I'm gonna be done here soon. Again, hold up. Give me 5 minutes. Shake my hands. CPS can be transferred state to state through interstate compact under the Uniform Child Custody Jurisdiction. That's right. Allowing the original to sit in state. Yes, but that doesn't. Yes and no. I've done an interstate, and the thing about an interstate is that there has to be court involvement, and the court has to be open to receiving that. The other jurisdiction has to be open to receiving that information. CPS from California can't call CPS from Nevada and just give information unless they have an open case and there is a interstate compact to that. But all of that is legal, guys. We're talking about something completely different than somebody calling in abuse and neglect of a child. Does that make sense? So this is very much like, I hear what you're saying, but that's only for like open CPS cases, if that makes sense. That's how you share information. Otherwise, there isn't anything else. I can't call Nevada and say, hey, Nevada, I have a child. I want to send that child over there. I can make contact, but I can't really give information until the courts are involved. And again, that goes with information sharing, privacy, especially if it's an open dependency and neglect case. So it's a little bit different, and it's not that easy to just kind of share info. Wasn't it Jake's grandma that was the informant or something like that? Maybe that's how he got special treatment. I don't know, Cynthia. I don't know, man. It's kind of, all this whole case is crazy, man. It's just like the more and more we find out, the more and more I'm just like in shock. Okay. But again, guys, find the documents in SF Investigates, because he dropped them yesterday and I missed them. But I'm going to try to get I emailed Riverside, but I have not heard back yet. And I'm willing to pay for the documents. I just need I need them to answer their email. Thank you. Oh my God, Sylvia, thank you, thank you, thank you. You found she dug in my purse and found a lollipop. Thank you, thank you. Thank you so much, Sylvia, for the 1999 towards courts transcript funds, because we know they're not free. Thank you, Rabbit. Thank you, Sylvia. When the welfare of a child is a question, privacy should go out the window, in my opinion. Yeah. Laws need to change, though. This process involves formal petitions. That's right. Court approval and coordination between state agencies to ensure child safety, best interests are met. You're absolutely right. But that's like, I could share a little something. When I worked in CPS, I've done a couple of interstate compacts. So like I did one with Pennsylvania, where it's an open, these kids were already in the system for many, many years, and the parent was in a different state, but the parent had been incarcerated. So like it was that having to petition my court, having to petition that court to then try to figure it out, and all kinds of things have to happen in between. The children's lawyers have to be in agreement. It is not as black and white as people make it sound. It's very much not at all. I will drop his link here. Okay. Hello. Here. Thank you. My goodness. So bratty. Why are you so bratty? Hold up. Let me this is SF Investigates link. You guys go check them out and you can find those. This is the link right here, y'all. Thank you, Cheeks. Thank you. First probation violation in Alabama, and you do probation time. He should have, but they kept pushing back. They kept pushing back all the time, if you know what I mean. Problem is this, these fold moves don't say anything. That's right, Grain. That only happens if the child picks up another case. He has another case regarding a firearm. This case, that case is kind of new, says me. Okay. And I'm going up a little bit. Just make sure I didn't miss anything. All right. Okay. I gotta pick up my kiddos from school, but thank you, thank you, thank you. All right, guys, I'm gonna go because I gotta make some lunch. I gotta do that, and I'm not done recording my Chris Hansen video. I'm almost done, but there's just so much information, so I gotta finish that up. Hopefully, I'm able to drop it tonight, if not tomorrow, just depending. But tomorrow for sure we'll be live for the hearing. There's also the Alexi Treviso case hearing as well tomorrow, so I'm gonna be divided into two. I might have to have like 2 computers. 3 computers. Luckily, I have everything. I have my old computer, everything set up, so we can definitely do it. Okay. You guys have a wonderful rest of your day, and I will see you guys later on. If you're watching the replay, thank you so much. Hit the like button. It does help. And shout out to everybody in the chat. I'll see you guys later. Thank you for supporting the channel. Bye, guys.